Barcast Audio Contracts Law Quiz 1. Question 1. Contracts. Consideration. A 24-year-old was negligently driving his mother's car. He crashed into another driver, a woman driving a truck. The injuries the son suffered during this crash ultimately resulted in his death. When he died, he had no assets. One of his creditors wrote to the mother, stating that the son owed him an electric bill of $300 and that he was going to file a claim against the son's estate. The mother replied, "If you don't file a claim against my son's estate, I will pay what he owed you." If the creditor did not file action against the son's estate, would the creditor succeed in an action against the mother for $200? A. No, because the mother has no obligation to pay her son's debts. B. No, because the creditor chose to believe the mother's promise to pay him and accepted all risk when he entered into this verbal agreement. C. Yes, because the mother's promise was supported by a bargain for exchange. D. No, because the creditor's claim against the son's estate was worthless. The correct answer is C. The correct answer is C, because the mother sought the creditor's forbearance in exchange for her promise to pay the son's debt. It does not matter that the creditor's consideration benefited a third party, the son, instead of the mother. Question 2. Contracts. Consideration. A foreign language professor was hired to teach a few courses at a university. She is now in her fourth consecutive one-year contract. State law holds that she cannot require tenure until she has completed 6 consecutive annual contracts. During this fourth year, she was notified that she would not be rehired for the following year. Applicable state law and college rules did not require either a statement of reasons or a hearing, and neither was offered to the professor. Which of the following, if established, sets forth the strongest argument the foreign language professor could make to compel the college to furnish her a statement of reasons for the failure to rehire her and an opportunity for a hearing? A. She leased a home in reliance on an oral promise of reemployment by the university president. B. The only reason the university did not rehire her was to avoid tenuring her. C. She moved closer to the university in anticipation of being rehired by the school. D. She was the only professor whose contract was not renewed that year. The correct answer is A. The correct answer is A, because if the president had made an oral promise, he should have expected to induce action with that promise in a statement of reasons, and a hearing may be necessary to remedy the situation. Because the professor leased a home in response to an oral promise of reemployment by the university president, a detrimental reliance on the part of the professor would be established and would provide a substitute for consideration. Question 3. Contracts. Assignments of rights and delegation of duties. On February 15th, a repair technician agreed to repair an owner's computer for $3,200. It was agreed that the amount would be paid after the technician completed the work. On March 10th, before the work was completed, the technician sent a letter to the computer owner with a copy to the technician's creditor, telling the owner to pay $3,200 to the creditor. The repair technician then completed the work on March 12th. Which of the following, if true, would best serve the owner as a defense in an action brought against him by the creditor for $3,200? A. The original technician-owner contract had not involved a creditor. B. The creditor was not capable of performing the technician's repair work. C. The technician had promised the owner that he would not assign the contract. D. The mechanic had not performed his work in a workmanlike manner. The correct answer is D. The correct answer is D, because the owner is not obligated to pay the technician unless the technician did not satisfy his contractual duties, which includes an implied duty to perform in a workmanlike manner. Since there was a valid assignment of payment to the creditor from the technician, and the technician performed, then the creditor can sue the owner for payment. The owner would prevail in this suit if the technician had not performed the work in a workmanlike manner in accordance with the contract. Question 4. Contracts, assignments of rights, and delegation of duties. An electrician, who had been in the business for over 20 years and had a good reputation, was contracted for a standard electrical installation at a local grocery store. The contract between the electrician and the store has no provision regarding assignment. If the electrician assigns a contract to a contractor who has comparable experience and reputation, which of the following statements is correct? A. There is a novation. B. The store owner is required to accept the work done by the contractor. C. The store owner may refuse to accept the work done by the contractor, even if the work is completed to a standard. D. The electrician has breached the contract. The correct answer is B. The correct answer is B, because a contractual duty may be delegated to another, unless the other party in the contract has a substantial interest in having the original obligor perform the duty or the contract provides otherwise. If the store owner refuses the work of the contractor, he will be in breach of the contract. Question 5. Contracts, assignment of rights, and delegation of duties. A patient was treated by a doctor. She owed the doctor $15,000 in medical bills for the care she received. The doctor orally assigned this claim to the patient's adult daughter as a wedding gift. Unfortunately, immediately after this, the doctor lost a great deal of money in the stock market, and assigned by assigned writing the same claim in her stockbroker in partial satisfaction of advances legally made by the stockbroker in the doctor's previous stock market transactions. After this happened, the patient, who was not aware of either of these occurrences, paid the doctor the $15,000 in medical bills she owed. The doctor promptly lost this money gambling. Assuming that Article 9 of the Uniform Commercial Code does not apply to either of the assignments in this situation, which of the following is a correct statement of the parties' rights and liabilities? A. Neither the daughter nor the stockbroker can recover from the patient, but the stockbroker, though not the daughter, can recover $15,000 from the doctor. B. The daughter can recover $15,000 from the patient, as the patient acted at her peril by paying the doctor. C. The stockbroker, as the sole assignee for value, can recover $15,000 from the patient, as the patient acted at her peril by paying the doctor. D. Neither the daughter nor the stockbroker can recover from the patient, but the daughter can recover $15,000 from the doctor. The correct answer is A. The correct answer is A, because when a contract is assigned to a party gratuitously, the assigner retains the power to revoke the assignment if done prior to receiving payment from the obligor, or before the assignee has relied on the assignment or brought suit to enforce it. Because the doctor had not yet paid the patient's medical bill, she still had the legal authority to revoke her oral assignment to do so. The stockbroker, however, never received payment, so the doctor's debt to the stockbroker is still enforceable. Question 6. Contracts, conditions. A furniture company signed a contract with a college dormitory building to sell them 60 identical sets of specified bed frames, 15 sets to be delivered on June 1st, and the remaining 45 sets on July 1st. However, the agreement did not specify the place of delivery or the time or place of payment. Which of the following statements is correct? A. The college only has to pay the furniture company after they deliver all 60 sets. B. The furniture company only has to provide the college with the bed frames after the college pays the company for all 60 frames, regardless of the current set delivery dates. C. The furniture company has no duty to deliver 15 sets on June 1st at the college dormitory, unless the college dormitory tenders the contract price for the 15 sets on that date. D. The furniture company must deliver the first 15 bed frames on June 1st, and the college must pay the company at the time of delivery. The correct answer is C. The correct answer is C because, according to the UCC, unless the contract specifies otherwise, a buyer's obligation to pay is conditioned upon the delivery of the goods by the seller. Therefore, The college dormitory is obligated to pay the furniture company when the furniture company delivers the bed frames immediately upon their delivery, and if the college does not pay the furniture company at that time, the furniture company has no obligation to deliver the bed frames. Question 7. Contracts. Formation of contracts. A barrel racer bought a 1-month-old registered foal at an auction from a breeder for $1,000. The contract did not include an express warranty. 13 months later, tests by a veterinarian concluded that the foal had been born incurably sterile and would have only been worth $200 at the time of the sale. In an action by the barrel racer against the breeder, to avoid the contract and recover the price paid, the parties stipulate that, as both were and had been aware, the minimum age at which the fertility of a foal can be determined is about 11 months. Which of the following will the court probably decide? A. The barrel racer wins, because both parties assumed the foal be fit for breeding. B. The barrel racer wins, because the breeder misrepresented the foal. C. The breeder wins, because any mistake involved was unilateral, not mutual. D. The breeder wins, because the barrel racer assumed the risk of the foal potentially being sterile. The correct answer is D. The correct answer is D, because, though the barrel racer could not have investigated the foal's fertility at the time of purchase, the barrel racer implicitly assumed the risk of the foal's infertility, since he was aware of this possibility, yet went forward with the purchase. Question 8. Contracts. Defenses to enforceability. A large chain store called a coaster manufacturer and offered to purchase, for $10 each, a minimum of 600 coasters and a maximum of 800 coasters to be delivered in a maximum of 20 days. The coaster manufacturer orally accepted this offer over the phone, then sent a letter, which was received by the store 1 day later, stating the agreement in writing. The letter, which was signed by the manufacturer, stated, "This confirms our agreement today by telephone to sell you 600 coasters for 20-day delivery." 14 days later, the manufacturer delivered 800, not 600 coasters. The store rejected all 800 of the coasters because it had found a better price from another supplier. Because of a glut in the coaster market, the manufacturer cannot resell the coasters without losing money. In a suit by the manufacturer against the store, which of the following will be the probable decision? A. The manufacturer can enforce a contract for 600 coasters because the manufacturer's letter of confirmation stated that quantity term. B. The manufacturer can enforce a contract for 800 coasters because that is how many the manufacturer delivered. C. The agreement is actually not enforceable at all, as the chain store never signed it. D. The agreement is actually not enforceable at all, as it did not include a written price term. The correct answer is A. The correct answer is A, because under the UCC statute of frauds, a contract for the sale of goods valued at over $500 is enforceable if there is sufficient writing to indicate that the contract had been made and had been signed by the party against whom enforcement is sought. However, when dealing with two merchants, the confirmatory memo rule applies. In contracts between merchants, if one party, within a reasonable time after an oral understanding has been reached, sends a written confirmation to the other party, it will satisfy the statute of frauds requirements against that party if the party knew of the memo's contents and failed to object to them within 10 days. This is why, despite the store not signing the written contract, the manufacturer can still enforce the contract. The contract does not need to include all the details of the contract to be enforceable, but is only enforceable to the extent of the quantity term stated in the writing, which is why the manufacturer can enforce a contract for only 600, not 800 coasters. Question 9. Contracts. Remedies. In February, a woman contracted with a summer camp to serve as its head director for 12 weeks for a salary of $20,000. In April, the camp notified the woman that it had hired someone else for the head director position and that her services would not be needed. The woman then spent $300 to travel to interview for only other nearby summer camps, which ultimately did not hire her. She then took a teaching position in a local swim school at a salary of $15,000 for the same 12-week period at the summer camp. In a breach of contract action against the camp, the contractor then hired someone else, to which the following amounts, as damages, is the woman entitled, if any. A. $20,000, as that was the amount the original contract was for. B. $5,000, as that is the difference between the woman's contract with the camp and her contract with the swim school. C. $5,300, as this amount includes the difference between the woman's contract with the camp and her contract with the swim school, as well as the amount she spent on travel to interview for the other camp. D. She is entitled to no damages because the camp broke the contract before she began work. The correct answer is C. The correct answer is C, because the goal is to put the woman in the position he or she would have occupied, but for the breach. If not for the camp's breach of her contract, she would not have had to spend $300 on travel to interview with another camp, and would have earned $5,000 more working for the camp instead of the swim school. Question 10. Contracts. Formation of contracts. A hotel offered a woman a full-time permanent position of head chef at a salary of $3,500 per month. The woman had indicated on her application that she was seeking a permanent position, agreed to take the position, and notified the hotel that she would begin work in 1 week. However, after working at the hotel for only 3 weeks, she was offered a position at a nearby high-end restaurant that offered her a salary of $4,500 a month. She accepted the position at the restaurant and promptly notified the hotel that she would be resigning as their head chef. Is the hotel to prevail in a lawsuit against a woman for breach of contract? A. Yes, because a contract for permanent employment would be interpreted to mean that the woman would not leave the hotel until a significant amount of time had passed. B. No, because a contract for permanent employment would be interpreted to mean the chef could leave at any time. C. Yes, because the woman's failure to give the hotel a chance to match the salary offered by the restaurant breached the implied right of first refusal. D. No, because the position at the restaurant was higher paying. The correct answer is B. The correct answer is B, because permanent employment means employment at will in this context. Either party can terminate this kind of employment at any time, for any reason, without that termination being considered a breach. Therefore, the woman would not be liable for a breach of contract, because she has the right to leave the contract whenever she would like to.